Right now, prosecutors are laying out their evidence in the murder trial of Derek Chauvin, the former Minneapolis police officer charged with killing George Floyd. People are making claims online about Chauvin's past use of force incidents, asking why the attorneys aren't bringing them up. Our Verified team dug through court documents and turned to an expert for the full context. Here's Gabe Cohen.
Right now, we're seeing a ton of tweets about Derek Chauvin's past, with claims that he's used excessive force several times. Some are asking why it's not coming up in court. So let's verify. Can the prosecution bring up use of force incidents from Chauvin's past? Our sources, court documents, police records, and a legal expert. Last September, prosecutors filed a request to show evidence at trial of 8 use-of-force incidents involving Chauvin to prove his knowledge of training and a modus operandi, basically a pattern of similar behavior. Chauvin's lawyer filed this objection, pointing to strict state rules about evidence of other past events, what's known as Spiegel evidence, which can't be used to prove the character of a person, but can prove things like motive, intent, and knowledge.
We put people on trial for what they did, not who they are, is what courts sometimes say.
Ted Samsel-Jones is a professor at Mitchell-Hamlin Law School in Minnesota.
You can't put in their past acts of violence in order to show that they have a generally bad character, that they have like a general propensity for violence, but you can sometimes admit those same acts for other permissible purposes.
Chauvin's team argued those 8 incidents don't meet that criteria. They write, Mr. Chauvin reported his use of force to the department in each of the above incidents, and in every single one, it was determined by a supervisor that Mr. Chauvin's use of force was reasonable, and the evidence would serve no purpose other than to fixate the jury on Mr. Chauvin's prior actions, which were not crimes. The judge ultimately decided the state could only bring up 2 of those events. The first, an August 2015 incident where court documents say Chauvin and other officers pinned and handcuffed a suicidal, intoxicated, and mentally disturbed man, and then moved him to the side recovery position, earning them a recommendation for a life-saving award. But the judge says the state needs to prove that Chauvin heard medical experts explain the risks had that man not been put in the rescue position, to show Chauvin's knowledge of reasonable force and standard of care. Then there's a June 2017 arrest where court docs say Chauvin dragged a woman out of her home, put her in the prone position face down on the sidewalk, much like Floyd, and even though she wasn't resisting, kneeled on her back. The judge decided the state can use it to prove modus operandi,
to show that he had a pattern of doing the same thing.
The other 6 incidents are inadmissible. The judge says prosecutors just wanted to depict Chauvin to the jury as a thumper, an officer who knowingly and willingly relishes in mixing it up with suspects and who routinely escalates situations and engages in the use of unreasonable force. So we can verify, yes, the state can bring up 2 use-of-force incidents from Chauvin's past during his trial. With your Verify, I'm Gabe Cohen.